Hi, welcome to today's program. This is the second program in our Negotiation Ethics for Lawyers series entitled Negotiation Ethics for Lawyers: How to Recognize and Respond to Dirty Tricks and Bad Faith Tactics. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking about legal ethics, including negotiation ethics topics, for the past 15 years, including having taught negotiation ethics for lawyers at Pepperdine Law School. I also have a lot of experience in the trenches negotiating with counterparties, first as a litigator at Davis Polk, then as an in-house lawyer at NBC Universal, and now as a business affairs executive at Sony Pictures, where I spend most days making distribution deals for feature films and TV series. Because I'm both a practitioner and to some extent an academic on these issues, I can give you the guidance you need to negotiate effectively on behalf of your clients while at the same time maintaining your professional reputation and always staying on the right side of the legal ethics rules. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of any of my current or former employers or institutions with which I've been affiliated. As I mentioned, the title of today's program is Negotiation Ethics for Lawyers: How to Recognize and Respond to Dirty Tricks and Bad Faith Tactics. Of course, dirty tricks is a loaded phrase. In the course of today's program, when you see some of the examples we use, it may well strike some of you, many of you, who are viewing that, wait, that's a dirty trick? I've seen that happen all the time, and I've even used that myself. While others may have the complete opposite reaction. Yes, of course, that's the dirtiest thing I've ever seen in a negotiation. It is important, and this will be a recurring theme in today's presentation, that people go into negotiations with very different expectations of what the rules of the game are. Something that one party may consider completely appropriate and routine, and just being a tough negotiator, may strike the opponent as something that's completely out of bounds. It's really important when we label something here a dirty trick or something that's a bad faith tactic. A lot of it is going to be in the eye of the beholder. That said, there are some clear rules as set out in the ABA Model Rules of Ethics and other sources, and we're going to spend some time today reviewing those rules to give you some guidance. But at the end of the day, anytime you're involved in a negotiation, it's often wise to step back and say, okay, this seems like a very dirty trick to me. Then maybe you label it, possibly even call it out in the negotiation, but don't let it bother you. There are many ways that you can respond and deal with things that will keep the negotiation on track, that will protect your client's interests. My advice would be not to get distracted by something that you say is out of bounds and a dirty trick, and to employ one of the recommended strategies for dealing with it in the negotiation. If the other side's conduct violates the legal ethics rules, there certainly would be an opportunity for you to make a state bar complaint if you think an ethics rule has been violated. And depending on the conduct, it could give rise to a civil claim for fraud or misrepresentation. But in any case, I think the message today is don't always assume that you have the same view of certain tactics as the other side does, and try not to get distracted by something that's being done to you. There are things you can do to protect yourself in the context of the negotiation, and we're going to cover some of those today. In thinking about the title Dirty Tricks, even the word dirty presumes a conclusion about which side of the line the tactic is on. I think here it's interesting to talk about the analogy to playing poker and the notion that all negotiation is simply playing a game of poker. There are a lot of similarities between the two, I think it's fair to say, but I also think that there's some limitations on poker as a metaphor. For one, I think that given the stakes in most of these negotiations, using a game analogy or metaphor sometimes encourages conduct that maybe doesn't really reflect the seriousness of the discussions. You can imagine negotiations where someone's life or freedom or liberty or meaningful rights or all of their assets could be at issue, and certainly not things to be taken lightly. I think that thinking of negotiation as a game of poker somehow diminishes the importance of the subject matter. And so that's a limitation. But to be fair, there are more similarities. Each side in a negotiation has different information. They know what cards they're holding, and they're trying to assess the strength of the cards they're holding against the strength of the cards the other side is holding. And they have limited information about those cards. What they're trying to do is make judgment calls about the relative strengths of their hand and the other side's hand. And how are they doing that? Well, they're listening to what they say. They're reading their body language. They're going through a betting process or bidding process and trying to gauge the reaction. Clearly, there are similarities, but again, the metaphor has its limits. For one, in the game of poker, there are clear rules. You can get a book, you can read the rules. And everyone knows that if you bluff in a game of poker, that's within the bounds of the rules. Some people even admire another player's ability to bluff and mislead them about the strength of their hand. On the other hand, if you're playing poker and you pull a card out from under the table, you're going to have everyone pretty outraged because that kind of conduct is clearly outside the bounds of the rules. In the Wild West, pulling a card out from under the table might even have gotten you shot. Poker is not like negotiation in at least that one very important sense. In poker, everyone knows what the rules are, and everyone agrees on those rules, including that certain types of misdirection or bluffing are absolutely permitted, and that pulling a card out from under the table and other types of cheating are absolutely prohibited. In negotiations, it turns out most people don't know what the rules are, including lawyers who negotiate on behalf of their clients and who are subject not only to the rules that apply to everyone, such as the law of fraud, but also to the legal ethics rules. Of course, that's why we're here today, to talk about those rules and to provide some clarity and guidance for lawyer negotiators. We're going to do three things today. First, we're going to use a hypothetical scenario to illustrate some potential dirty tricks, suggest ways that can help you spot them, and then suggest some ways that you can respond, things that you can do that would be potentially fine under the ethics rules. Maybe some things, if you're responding to a dirty trick in kind, might give you reason to pause and think twice about doing that. Second, we're going to review the legal ethics rules that apply to lawyers as negotiators. Third, we're going to discuss some negotiation techniques and strategies that I think will be very helpful to you in your negotiations and in responding to any potential dirty tricks that you may encounter. Let's get right into the hypothetical that we're going to be using today, and it's one that's near and dear to my heart as a lawyer working in the entertainment industry here in Los Angeles. We have an aspiring television producer and current coffee shop server, Alfonso Spears, who has an idea for a new reality TV show called Puppy Love. His concept? After an eccentric widow leaves her fortune to her prize labradoodle Kiki, 6 contestants compete to win Kiki's love and with it, her $5 million inheritance. And like all good treatments and pitches, it ends with hilarity ensuing. Ricky, aka Slick Rick Stratton, owns an upstart reality TV production company, Silver Spoon Productions. Flush with success from his breakout hit, Your Dingo Ate My Baby, Rick is always sniffing around for his next project. Over a decaf skinny no-foam latte, Rick invites Alfonso to pitch Puppy Love, and Rick accepts a detailed written treatment from Alfonso. Not entirely surprisingly, Alfonso never hears from Rick again, and that fall, a show called Dog's Best Friend premieres on the Animal Network. The show, which is produced by Rick and Silver Spoon, is oddly similar to Alfonso's concept for Puppy Love. What does Alfonso do? He goes and hires Kate Summers, who is an industry litigator, a self-proclaimed legal pit bull, to represent him in this dispute with Silver Spoon. In a barking letter, Kate accuses Silver Spoon of stealing Alfonso's idea for Puppy Love and insists that Alfonso receive proper creative credit on Dog's Best Friend, a salaried producing job, and a healthy share of the show's profits. Silver Spoon counters that Dog's Best Friend was created independently from Puppy Love, and that the similarities aren't enough to state a legal claim anyway. Silver Spoon is represented by its sole in-house lawyer, Edward Stratton III, who happens to be Slick Rick's brother. Kate and Edward are now negotiating to try to resolve this dispute between Alfonso and Silver Spoon. Lastly, and importantly, while each is an industry veteran, they do not deal regularly with one another. This touches on something that we'll cover in more depth later, but we purposefully created a situation where these folks are not going to deal with one another often. And the reason we've done that is because you tend to see sharper practices when negotiators are not concerned about facing one another later. Obviously, to the extent that these people deal with one another regularly, their conduct would probably be more circumscribed, more reasonable. They would be more concerned about their reputation in that case. They would be concerned about any deceptive practices not being effective and therefore preventing them from competently representing their clients. So it's important to note that they don't expect to see each other again, and I think that's going to explain a lot of the conduct that we see later. Let's take a look at the first scene.
Listen, Edward, I took your call, but I'm not prepared to negotiate. If you don't accept in full the terms as proposed in our letter, we're moving forward with a lawsuit. I have no doubt any jury would award us triple what we asked for.
What's going on in this scene is pretty classic take it or leave it, basically negotiating by trying not to negotiate. Kate is trying to shut down any negotiation right off the bat by saying, I've made my demand. If you don't agree to everything that I've said in my letter, we're going to file a lawsuit. The ethical issue here is that Kate's client has not authorized her to file a lawsuit. In fact, he said very clearly that he wants to resolve this without any litigation. Kate is clearly getting ahead of her client and making a threat to Edward that is also not authorized, but also potentially being made in bad faith. What should we think about this scene? Before we get into the ethics of the statement or the misrepresentation, we need to think about Kate's comment in terms of what her client actually said to her. There is a chance that what Kate is doing here completely blows up, and the other side takes what she's saying at face value and says, well, I'm not prepared to do those things. What I've heard you say is that absent these things, you were going to end up in litigation. You could even potentially see a preemptive lawsuit filed for declaratory relief, perhaps in an unfavorable jurisdiction. You could see this ending up in litigation unnecessarily, and all because Kate was taking too aggressive of a position without having her client on board. The first piece of practical advice for Kate is if you want to go down this road, you'd better have a conversation with your client first and say, listen, I want to take a very aggressive position here. You need to understand that if I do that, there's a chance that this blows up in our face and then we end up in litigation, which is where you're telling me we don't want to be. I hear you loud and clear on that, but I still think this is the better approach. You just need to understand as the client that this represents at least some risks. That approach at least would remove the issue of the lack of client consent if Alfonso agreed to this strategy. Even if Alfonso consented, it is still a very high-risk strategy for Kate because unless Edward completely capitulates and gives in to everything immediately, it's going to go sideways for Kate because she's either got to file or not file. It is important if you ever get out ahead of your client like this, even if you think you might be very effective in making a take it or leave it threat, or we also call it playing a game of chicken, that if you don't win, if you're wrong, it actually can only go badly for you at that point. While it's clear that Kate should have had that conversation with her client in advance, some lawyers would counter, well, the client decides upon the goals and the final resolution, but in terms of the methods of getting there or the tactics to employ, that's really more my decision as the lawyer. But certain tactics carry with them risk, and if you don't discuss those risks with your client, you don't want to end up on the wrong side of the little V in a malpractice case if you end up in litigation for engaging in a tactic that your client has told you expressly they're not interested in having you engage in. Let's now take a look at the specific comment that she made. First of all, the comment, I'm sure any jury will award us more if we end up deciding to sue, is going to be regarded as a statement of opinion or a prediction of future events, and not as a statement of fact that might be false. Most reasonable lawyers who've been practicing for more than a day are not going to rush to write a check and capitulate in that situation. So that statement is not on its own going to be a problem. One could even argue that the statement, we're moving forward with a lawsuit, is not itself a factual statement, but rather a statement of his or her client's present intention. I suppose in this case you could argue that this is not in fact her present intention, so it's a straight misrepresentation, but I'm not quite sure how you're going to prove what her intention was. You could look at what the client instruction was, but you're never going to get to that because that information is privileged. In any case, this is a very common tactic, and I don't think the analysis really here is as much whether it's ethical, is as whether it's likely to be productive. We should remember that the fundamental duty of a lawyer is competent, effective representation. I think some lawyers sometimes overestimate their ability to engage in these hardball tactics in an effort to move or sway the other side, when in fact it's not likely to be taken seriously. If, on the other hand, it is taken seriously, there are very dire consequences if you end up in this protracted litigation, and at the end of the day, Kate is going to lose credibility because the other side is not going to capitulate, and everything that she says from this point forward is going to be viewed in light of this earlier threat, which was hollow. It's not surprising that Kate would want to make this kind of a statement. If you think about what her underlying interest in saying this is, she's trying to create the impression that absent agreement on these things, she's going to move ahead with the lawsuit. So what is a lawsuit? Well, that's her alternative to reaching a negotiated agreement. And for those of you who've had some training in negotiation theory or strategy, especially the Roger Fisher and Bill Urey book, Getting to Yes, they refer to this acronym that we hear from time to time, BATNA. What does that stand for? BATNA is Best Alternative to Negotiated Agreement. In any situation in a negotiation, there are at least two alternatives. One of them is to reach an agreement in the negotiation you're having, and the other is the best alternative to reaching a negotiated agreement, which might be filing a lawsuit seeking to recover on the client's claims. Each side is going to have an alternative, and the relative leverage in the negotiation will turn, at least in part, on the quality of those alternatives, or BATNAs. Here, Kate is trying to generate leverage and momentum so that she can get the negotiated agreement she wants by saying that the alternative that she has is filing a lawsuit. It turns out that her client hasn't authorized the filing of the lawsuit, but she's trying to make that appear viable and something that her client is willing to do in order to make her leverage stronger to reach the negotiated agreement that she would like. This tactic is very common. I should note that if you were to try something like this with a larger entity, say a larger studio hypothetically, you're very likely to have a negative response because anybody that negotiates things as a matter of course is going to say, look, we're not going to negotiate with a gun held to our head, or some people will say euphemistically, we're not going to negotiate with terrorists, meaning no one can come up to us and make threats and get what they want. We're simply, as a matter of principle, not going to do business that way. And I think that if this had occurred with two parties where one was much larger, more sophisticated, more involved in negotiations on a day-to-day basis, you would likely see a negative reaction. We include it here because we've got a smaller production company where the tactic may be somewhat more effective. Now, let's think about what Edward might say in response. And we're going to see a little bit later two actual examples of that, and I'll just mention them briefly now, and we'll discuss them in detail after we've done a review of the legal ethics rules that apply to lawyers when we negotiate. The first thing he could do is respond in kind, saying something along the lines of, well, fine, if you file a lawsuit, we'll never settle with you, we'll litigate forever, it'll cost you hundreds of thousands of dollars, and you don't have that money to litigate with us. One way to respond to chicken or take it or leave it is to say chicken or take it or leave it right back. That's also a very high-risk strategy, just like the one that Kate is employing. And the reason is if you respond to a threat with a threat, one of you is going to have to back down, or you're both going to have to go through with your threats. If you make a threat and you don't go through with it, you lose credibility, as we were suggesting Kate might be doing here, because her client has not authorized her to file a lawsuit. The second thing you could do is just ignore the threat. You could say something like, I'm happy to continue to discuss this, but I'm not going to be influenced by what you say will happen if we don't reach a deal. There isn't anything wrong with ignoring threats someone is making to you, but it may or may not be effective depending on the person that you're dealing with on the other side. If they feel that you ignoring them forces them to execute on the threat, then you haven't really gotten anywhere. I think those are two of the reactions that most people would instinctively think of in this circumstance. And as we'll see in a few minutes, probably neither is really the best way to go here. There are actually some more creative and I think more constructive ways to respond to something like this. At this point, we need to take a brief detour to talk a little bit about general negotiation strategy. This is not the time or place to squeeze in an entire course on negotiation theory into the program, but I'm going to be using some jargon that comes from the literature that would be useful for us to talk about, such as the concept of BATNA, the best alternative to a negotiated agreement, that I mentioned already. Most of this comes from the classic book Getting to Yes by Roger Fisher and Bill Urey. I was fortunate enough to have Roger Fisher as a professor at Harvard Law School before he passed away, and to take his course on negotiation theory and strategy. Among Professor Fisher's many insights were that there are four fundamental concepts at work in successful negotiations. The first one is to separate the people from the problem. I think we've all seen examples where emotions are running high. There may or may not be history between the parties and people's styles are just not meshing well. And you end up having a situation in a negotiation where the participants end up unduly focused on the people involved, maybe the principals or maybe the negotiators or both, such that they're not thinking about the problem just as a problem to be solved and really sitting down together and trying to solve that problem. It becomes more about scoring points against one another. Obviously, that's not going to be productive. And so when you find yourself getting carried away with the people or the personalities and the psychology of it, sometimes it's helpful to simply set that aside and try to think about the problem. Ultimately, those emotions are going to be relevant. You can't ignore them, but it's helpful to at least start with the problem and then think about how the personalities influence the way that you address the problem, and to try to keep the two separate. The second one is to focus on interests, not positions. What do we mean by that? When a party comes up and says, my client wants X, X is not their interest, X is the position. It's based on some underlying interest that they probably haven't articulated very well. When someone comes up and says, for example, I need $1 million, that's a position. Probably not a position most people are going to want to live with. What you need to do is to try to understand the interest. Help me understand why your client's making that demand. Help me understand what interest is underlying that. What can you tell me about the demand? Where is this coming from? These types of questions will help discover the underlying interest. In many cases, if you identify the underlying interest, it might be benefit. In this case, it might be financial stability. It might be respect in the community. You can think about other more creative ways to try to meet that interest without having to accept the position that they've articulated. I'm going to talk a lot today about how to get at people's underlying interests, because that ends up building some momentum in the discussions and builds some trust, whereas focusing on positions is what tends to box you into a corner, much more than focusing on interests. The third concept is inventing options for mutual gain. I know that sounds very ideal. In some situations, you may feel like it's completely zero-sum and that there's no way to have mutual gain. But in general, the thinking is rather than taking a purely distributive mindset, for example, thinking that there are 10 $1 bills on the table and we have to distribute those 10 bills somehow, and I would like to have 6 and you would like you to have 4, you would like for me to have 4 and for you to have 6, where you end up spending a lot of time trying to get close to something that's 5 and 5. What does it mean instead to invent options for mutual gain? It means to try to figure out how to turn the $10 in the middle of the table into $12. Then we can each have 6. It's not always possible. It takes a lot of hard work and creative thinking. But in general, I think that people dismiss that idea too quickly because it is hard work. And they're so focused on what's in the middle of the table that they don't think about other things that can be brought in. Typically things that I may value less than you value. Those are perfect things to bring into the discussion. If I value something in a way that's lower than the way that you value it, now we can trade because there are probably things on the other side as well that you value less than I do. That's the classic win-win situation. It's easy to talk about on paper, and those of you who've been doing this for a while can appreciate how difficult it is. But I think sometimes people use that as an excuse not to try. And in general, I've found that putting the time and effort into that very often bears fruit. The fourth concept is to insist upon using objective criteria. You can imagine examples where you're going to have a disagreement, either during the negotiation or during the performance of the contract, where a more subjective standard or looser contract language is going to cause you to talk past one another and have disputes. By contrast, the more specific, the more concrete, the more objective you can be about measuring how each side performs under the contract, the smoother things are going to go. We're not going to try to do an entire course on negotiation theory and strategy here, but I do want to give you a sense for some of the language that I'm going to use. With that in mind, there are a few more important points I need to cover. I talked a little bit about how asking questions is going to be key if you want to have an interest-based bargaining instead of positional bargaining. You should always be driving for what the interest is so that you can get beyond the other side's stated positions or demands. A classic example to illustrate the difference between integrative or interest-based bargaining and distributive or positional bargaining is negotiating over an orange. We take a single orange and we put it on the table here between you and me, and then we try to figure out how we're going to divide it. Well, one might think that we would draw lines and try to figure out how to get it to exactly 50-50. Or maybe I'm trying to be clever and I'm trying to cut it in a way that gives me a little bit more. Imagine that happening in the context where we're really not communicating with one another. Now let's change that a little bit and talk about interests. And let's talk about asking questions of one another to try to get at those interests. So now we're having a conversation and I say, there's an orange between us. Are you interested in that orange? And you say, well, yes, I am interested in that orange. And I say, well, help me understand why you're interested in that orange. And you say, well, I'm interested in that orange because I'm trying to make orange juice. So I think about that answer. Well, what does that mean? Well, his interest is in having the contents of the inside of the orange. Let's say in this hypothetical, I'm making cocktails and all I need is the orange rind. I don't need to have any of the inside of the orange. And if we had not had that conversation, if we had not asked any questions about one another's interests, we would have split that orange right down the middle or something close to it. On a good day, maybe I'd get 51%, I suppose. And each of us would have only half of what we want. But by asking questions and trying to understand one another's interests, I get the entire peel and thus 100% of what I want. And you get the entire inside of the orange and thus 100% of what you want. That's because we asked questions of one another to try to discern what the other side's interests are. Now, how many negotiations in real life are over oranges? 0. How many of them are that simple? 0. Is there a point here? Yes, and it's a critical one. Don't assume that what you're trying to get out of a transaction is the same as what the other side is trying to get. And when these things end up being different, now you have an opportunity for mutual gain, and that's really worth exploring. Typically, when you're talking about a cash situation, you're in a distributive mindset. $1 more for me is $1 less for you, and vice versa. But even when you're talking about cash, if the parties are differently situated, cash may be more or less important to one of the parties. They may have different risk assessments or different risk appetites, different profiles. They may be more or less diversified as a company. They may be more willing to pay cash out early as opposed to receive it later. So again, these are areas where having a dialogue, asking the other side what their interests are, does not convey weakness. If anything, it conveys intelligence and creative thinking and an effort to try to work together to reach a result that is potentially better than you would have if you were simply trying to distribute a fixed pie. We can relate this advice to this particular example of Alfonso, who wants money for his idea, but also wants to be a producer and have producing credit. One way to think about this concept is if you had a true interest-based discussion and you said, okay, what are you really interested in? And Alfonso said, well, I want some money, but I'm really interested in the credit because if I get a credit for this, that's going to open doors for me and I'll be able to sell my next treatment. For a studio, giving a producing credit may be relatively costless. If it's a producer credit, but there's no producing fee, that could be something the studio could say, okay, fine, now I understand why he needs what he's asking for, and I can give that to him relatively costlessly, and I can save some money, which is maybe more important to me. But maybe it's the opposite. Perhaps the studio really can't give the producing credit as a matter of policy or precedent, because they don't want to concede that this idea was in any way created by anyone other than their folks, and thus it's a non-starter. But at least you've had the discussion about why Alfonso really wants the credit. Then you can get to an area where the pie potentially could be expanded, as opposed to just haggling over money where $1 more to Alfonso means $1 less for the studio. Even some very experienced negotiators downplay the ability to ask questions about interests and meet those interests with different positions. Here's another example that I think refutes this notion. I was upgrading my laptop computer, getting rid of my old laptop at the same time. That laptop was 3 years old, and the person that I was discussing this with said to me, well, this thing is old, it might be unreliable, I need to take $500 off the price. So I started asking more questions. Well, tell me about your concern, what are you concerned about? And this person said, well, what if this breaks, or what if that breaks, and then I'm going to have to go and pay and fix it. So now I understand the underlying interest is reliability. I want a reliable computer. The position that this person's articulating is $500 off the price. Well, I was able to say, I have a warranty. In this case, it was an AppleCare warranty that I had extended, and I said, well, that should deal with all of your concerns about having a reliable computer, so I don't need to accept your position that the computer should be $500 less expensive. I can meet your underlying interests or concerns about reliability in some other way. This isn't rocket science. We're talking about simple questions and answers. When somebody articulates a position to you, unless it's just completely obvious what they're trying to do, I think it's worth spending the time to say, help me understand your concern there. And in that case, the person was very forthcoming, reliability. Then you have an opportunity to meet that interest another way. The final point here is that in thinking about BATNA, or best alternative to negotiated agreement, always remember you are not the only party that has a BATNA. If you spend all of your time trying to figure out what your alternatives are, you'll be doing exactly half of the analysis that you need to do. You also need to think about your opponent's best alternative to a negotiated agreement. The classic example here is walking into a car dealership. If you're in an auto mall and there are many other dealerships there, the customer's best alternative to a negotiated agreement with dealer A is perhaps a deal with dealer B. The dealer has his own set of BATNAs, and his BATNAs, best alternatives, would be negotiating a deal to sell that same car to a different customer. If you're the customer, you're looking around to see how many cars are on the lot and how many other customers are there to figure out what the dealer's BATNA is. And if you're the dealer, you're looking to see whether the customer is coming in with a pile full of brochures from your competitors because you're trying to evaluate what their alternatives are. BATNAs are among the most material aspects of negotiations, which makes it highly problematic when you have participants lying about their BATNAs, which is prohibited by the legal ethics rules, or overstating their degree of confidence in their BATNAs, which is probably not prohibited. It is worth noting that this example illustrates another important point about leverage in negotiations. We talked about the idea of alternatives and your BATNA, the best alternative to negotiating an agreement with the other party. And the best negotiators understand that alternatives can work in both directions. As a negotiating party, you're thinking about what your own alternatives are, but you're also thinking about what the other party's alternatives. So here we have a statement not about one's own BATNA, but about the other party's BATNA. At the same time that this negotiating party is attempting to build up their own BATNA and therefore acquire more leverage, they're trying to beat down the other side's BATNA in order to suggest that they know that they don't have much leverage at all. That's one reason why telling lies that relate to alternatives, either your alternatives or the alternatives available to the other side, can get you into trouble very quickly because those statements are almost always material to the negotiation. That's a good segue to review the legal ethics rules that apply to lawyers when they are in negotiations. I do want to get into this hypothetical, talk about some potential dirty tricks and some potential responses, including some negotiation strategy that will help you when you negotiate, but some discussion of the rules is necessary. The first thing you need to remember is that lawyer negotiators are subject to the rules of professional conduct. In some sense, we are slightly differently situated than a non-lawyer negotiator, who is not subject to the legal ethics rules, but at the end of the day, it's my firm view that even though the legal ethics rules do apply to lawyers and don't apply to non-lawyers, anything that you think about doing that would be a violation of an ethics rule is really a bad idea in terms of business conduct, in terms of your reputation, and in terms of potential civil liability. In general, the standards match up pretty well, and I don't buy into the notion that lawyers are in any way handicapped when they negotiate because we are subject to the legal ethics rules. It's important to know, though, that the legal ethics rules only apply to lawyers when you are acting as a lawyer. If there's a situation where you're not representing a client and you're negotiating directly, so my example when I was negotiating with somebody over the purchase of my laptop computer, I'm acting as a principal there and not as a lawyer. The next point is whether lawyers have a duty to negotiate in good faith. The short answer is no. The longer answer is that, in general, in the United States, there is no independent duty to negotiate in good faith, because neither the law nor the legal ethics rules require the parties to negotiate in good faith. We do need to distinguish a few things. If you're under a contractual duty to negotiate, let's say you have a first negotiation, first refusal provision in a contract, or a duty to negotiate an extension, for example, the law would imply a duty of good faith in the performance of that contractual obligation. As we all remember from first-year contracts, the law implies a duty to perform all contractual obligations in good faith, which then would include contractual duties to negotiate in cases where such a duty is part of the contract. But that's a specific case, and absent that, there is no general duty of good faith to negotiate. Now that said, there are two caveats to this. The first is there are some aspirational guidelines, including some published in California, about civility that do suggest that lawyers should act in good faith when they are negotiating. But it is not something that's strictly speaking binding on lawyers. The ethics rules, as we'll see in a second, plus judicial decisions, are the things that bind lawyers, not these aspirational guidelines. But there are some aspirational guidelines out there that do suggest that lawyers should negotiate in good faith. The other caveat is that we're talking here about U.S. law and the law in the various U.S. states. In some European jurisdictions and in China, for example, there can be a general duty to negotiate in good faith. Setting those caveats aside, the fact that there is generally no duty of good faith in negotiating is a point that's very often misunderstood among lawyers and even some judges. Lawyers often levy charges against one another of negotiating in bad faith, but usually they're just describing some conduct that they don't like or that they find takes a sharp edge, and it's not really talking about a violation of some independent duty to negotiate in good faith. There is no independent duty, absent a contractual obligation, to do that in the United States. And it's a better practice to negotiate in good faith. You're going to have a better result. You're going to form better relationships. You're going to have better encounters with those people later. The contract is more likely to go smoothly if the process has gone smoothly. So I think the take-home message here is for all the reasons that we mentioned earlier, why in many ways interest-based bargaining is a way to get to a better result, get to a more durable result. You're engaging in bad faith just to get a capitulation essentially may not produce A, the best agreement, or B, a durable agreement, one that isn't going to be challenged later, isn't going to be the subject of a claim, or just isn't going to be performed well by the side who feels that they were taken advantage of by some bad faith negotiation. Turning now to the legal ethics rules, the place to start is with the ABA model rules, which are now followed by the vast majority of states, including California and New York. and specifically ABA Model Rule 1.3. Model Rule 1.3 provides that a lawyer shall act with reasonable diligence and promptness in representing a client. This is pretty familiar, I'm sure, to most viewers, if not all. This is the duty of zealous advocacy, the thing that we all learned in law school, the thing that is a heightened duty for criminal lawyers, but generally for all lawyers, you do have a duty to represent your client zealously within the bounds of the law. What I'd like to focus on also is in the comment to this rule that makes it clear that while a lawyer must act with commitment and dedication to the interest of the client and with zeal and advocacy on the client's behalf, a lawyer is not bound to press for every advantage that might be realized for a client. The way I like to think of this rule is there's a general duty of zealous advocacy that we all operate under. And those of us who practice civil law, it's not that heightened duty in criminal, but you want to represent your client zealously. What that really means in the context of a business transaction or negotiation is that you're not obligated to crush the other side. You don't have to get every scrap off the table or force them into submission. You can be reasonable and you can negotiate for those things that are most important to your client, and you don't have to get absolutely every last dollar, every last penny off the table. That's how I look at that rule. A nice companion to ABA Model Rule 1.3 is ABA Model Rule 2.1, which sadly doesn't get that much attention even though it's been around as long as many of the other rules we will discuss today. ABA Model Rule 2.1 talks about the role of morality in advising clients. There's a specific section that says that a lawyer may, not must, but may, advise a client with respect to morality. We can imagine an opportunity that a lawyer might have to engage in sharp practice where they, instead of feeling obligated to engage in that conduct, had a discussion with the client and explained why something might be technically within the law and ethics rules, but implicate notions of fairness and justness and morality. That's certainly fair game, and it's the kind of thing that hopefully lawyers are talking to their clients about, as opposed to setting an example for really the most aggressive or egregious conduct in negotiations. I will confess to being hard on lawyers when I discuss negotiation ethics, but it bears mentioning one other thing that goes on in the real world. Your client presses you to take a very extreme position. Often, you're in a spot where you're negotiating not only with the other side, but with your client about why taking a dodgy position or a sharp edge, something that's arguably crossing the line, isn't really in the client's interests. I think a lot of that's going on, and we're focusing on a hypothetical where it seems like this is coming from the lawyer, but it could very easily be coming from the lawyer's client saying, you got to go out there and get me the $1 million that I want. I don't care what you have to do it. You're my lawyer. You need to be a zealous advocate for me. I think there's a lot to this. We may have more or less control of our client depending on the situation, but Rule 2.1 does give us cover under the ethics rules to attempt to persuade a client not to take an immoral position. You should use it when needed. I was only following my client's instructions is not a defense to a legal ethics violation, nor is it salve for a badly injured professional reputation. The next rule to focus on is ABA Model Rule 8.4, which provides that it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. The way I think of this is, in being a zealous advocate, you're not allowed to lie, which is to say you're not allowed to make a false statement of material fact. You're not allowed to commit fraud, you're not allowed to commit deceit, you're not allowed to misrepresent. This is very important, and lawyers need to know that if you are engaging in this conduct when you negotiate, lying, misrepresenting facts, being deceitful, you are violating the legal ethics rules and could subject yourself to discipline. You also could open up your client to an action for fraud. This is a good place to make a distinction between the ethics rules and a cause of action for fraud or for misrepresentation or deceit. We're going to talk and look at these hypotheticals and analyze them to see, okay, have you arguably violated your ethical duties and what might be the remedy for that? One other thing to worry about is a possible cause of action for fraud. If you've committed an act in a negotiation, whether it's an ethical violation or it isn't, the other side could sue your client for fraud. They can make a claim that you've made a false statement, that it was material, that they relied upon it to their detriment, and that they've suffered damages. Because there's always the possibility that the other side could bring a fraud claim based upon your conduct in a negotiation, I would urge you to follow the guidance that I'm presenting to you today. Another important thing you should be concerned about if you lie, misrepresent facts, and act deceitfully in negotiations is your reputation. You're going to be dealing with a lot of the same people in your practice over and over again. I work in Los Angeles, and you might think, well, that's a huge metropolitan area. I'm sure there's hundreds of thousands of lawyers. But in reality, it's a pretty small community when you're talking about the entertainment industry. It's rare that I deal with somebody that I don't know or where I don't know somebody who knows that person. And if you get a reputation in your community for sharp practice, that could really be a detriment to you and to the clients you represent. Let me explain what I mean. If I'm negotiating with somebody who I know has a reputation for sharp practice, I'm going to be extra careful with that person. There might be reasonable accommodations that I would make for people that I deal with regularly who I feel are straight shooters. With some of those folks, I could get a deal done in a day and feel comfortable relying on an email confirmation even before I know the contract is done, because I know and I trust them. If I don't trust you, I will make you document every statement you make to me that I can't independently verify before I will rely upon it, and that process can take a very long time. I'll also likely take a harder line against you if I believe you're a shady negotiator, because I expect you'll be doing the same in your dealings with me. If this type of negotiation takes longer than your client wants and ends up delivering less value to your client than another lawyer could have obtained, you will end up being less effective for your client precisely because you have a reputation for sharp practice. Our next stop is a critical rule for lawyer negotiators, ABA Model Rule 4.1. This is a rule that we will come back to again and again. Here is what the rule says. In the course of representing a client, a lawyer shall not knowingly, A, make a false statement of material fact or law to a third person, or B, fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited by Rule 1.6. The language starts, in the course of representing a client, a lawyer shall not knowingly. Then we have a couple of examples of things that the lawyers may not do. Let's look closely at this clause because each of the words turns out to be quite important. First of all, it starts off with, in the course of representing a client. Someone whose conduct has been challenged, if they're a lawyer, they're very likely to go back to the beginning and say, wait a minute, this was not in the course of representing a client. I may be an attorney, I may pay my bar dues, I may be listed on the bar website, but I'm a business person. I'm somebody who functions as a lawyer most of the time, but in this context, I was merely negotiating. I'm just a regular business person, so therefore, the rules of ethics don't travel with me. While you could attempt to make this argument, it's very dangerous for lawyers to pick and choose when they're functioning as a lawyer and when they're functioning as a business person. Sometimes this issue comes up in the context of what types of communications may be privileged. Unfortunately, for the lawyers who are picking and choosing their moments, the same lawyers that are wanting to claim that their communications are privileged and can't be discovered, say in a litigation, may be the same ones who want to say that they're not governed by the rules of ethics. In general, if you're an attorney and you are performing the role of negotiating, that's a pretty standard role that lawyers play on behalf of clients, and you should assume that your conduct is going to be subject to the ethics rules. The next key word in Model Rule 4.1 is knowingly. The rule provides that a lawyer shall not knowingly make a false statement of material fact or law to a third person in Section A, and then in Section B, knowingly fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. If a lawyer did not know a statement of fact was false at the time he made it, that conduct would not violate Rule 4.1. The word material obviously is another potential escape hatch. First of all, we're talking about false statements of fact. We're not talking about opinions. We're talking about statements of fact. So this pie is really good is going to fit into one category, and there are 3 pieces of pie when there are in fact 4, and that's going to fit into a different category. And as simple as that example may sound, I think people would be surprised at how often opinions are confused with statements of fact. And it's not just any type of statement of fact. It has to be a material fact. So it may well be, I'm happy to negotiate with you, but I have an appointment today at noon. And if that's untrue, is that a statement of material fact, or is that really a statement about the context? Is that a statement about something that's not material? It may be a very bad idea for me to do it in terms of our relationship, but at the same time, is that going to be grounds for an ethical violation? I think people would argue that that kind of statement is not material. Putting it all together, you can imagine a crafty lawyer arguing in the alternative, something like, first of all, this was not in the course of representing a client. Second, they'll say, well, I did make a statement, but it wasn't knowingly false. It may have turned out to be false, so they'll hinge on that word knowingly. And then they'll say, third, sure, it was a knowingly false statement, but it wasn't material. Of course, that always raises my favorite response, which is, well, if it wasn't material and you didn't think it was going to make any difference, then why did you bother to raise it and emphasize it and stress it? While you could make all of these arguments, Model Rule 4.1 actually sets out a pretty clear standard for lawyers to follow and gives us fair notice that we can face consequences if we fall short. As important as Model Rule 4.1 is, the comment is arguably more important because it is attempting to unravel what it means not to knowingly make false statements of material fact in the context of negotiations. The comment begins by observing that, under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. Estimates of price or value placed on the subject of a transaction, and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category. And so is the existence of an undisclosed principal, except where non-disclosure of the principal would constitute fraud. Let's look at each of these examples in turn. Number one, estimates of price or value. For example, hypothetically, the value of a script. This is a very valuable script. This script is worth $10 million. That would seem to be covered. Number two, intentions as to an acceptable settlement of a claim. We hear all the time, we have no intention of settling this case for less than $1 million. Third, the existence of an undisclosed principal. Think of a lawyer who is representing a developer who wants to buy up several parcels anonymously, which is common in real estate. Think of Walt Disney buying several small farms in Anaheim so that he could build Disneyland, and not wanting any of the sellers to know that he needed all of their farms to complete his plans. If any farmer knew what Walt Disney was up to, that farmer would have had a hold-up opportunity, and that would be what Disney was trying to avoid. Because this practice is common in negotiations, the comment is saying that a lawyer doesn't violate Rule 4.1 by failing to disclose the existence of an undisclosed principal. People sometimes wonder when a lawyer's failure to disclose the existence of an undisclosed principal would constitute fraud, thus falling outside this exception and being actionable under Rule 4.1. Perhaps the best example is a lawyer who represents a borrower who has defaulted on a loan. The lender is now seeking to sell off the loan at a discounted price. If the borrower then asked his lawyer to represent him or an affiliated party in negotiations with the bank to purchase the loan and to conceal his identity from the bank in that process, the lawyer's failure to disclose the identity of her client in that case might constitute fraud. That's because the bank might not be willing and potentially might not be able, under either its internal rules or government regulations, to sell the loan back to the original borrower. This makes the identity of the client a material fact that the lawyer cannot fail to disclose, consistent with the requirement of Rule 4.1. Another interesting point here is that, unfortunately, I think the comment does a little bit to confuse readers because of how these exceptions are described. The comment identifies these types of statements as not being statements of material fact, so estimates of price, intentions as to an acceptable settlement, and undisclosed principal are not statements of material fact. It attempts to use that as the justification for not making them ethical violations. The problem is that these are statements of material fact, which makes the ABA's guidance confusing. It would have been better if the ABA had said, these are material statements of fact, they're just not the types of things that we would expect a reasonable person on the other side to rely upon. Regardless of the justification, these are the types of conduct or statements that are going to be accepted from Model Rule 4.1's prohibition on making knowingly false statements of fact or law. The other key part of the comment is the following section. A lawyer is required to be truthful when dealing with others on a client's behalf, but generally has no affirmative duty to inform an opposing party of relevant facts. A misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. Misrepresentations can also occur by partially true but misleading statements or omissions that are the equivalent of affirmative false statements. The first part is straightforward. There is no obligation to tell the other side relevant facts in a negotiation. The next part confirms that a misrepresentation can occur if the lawyer affirms a statement of another that the lawyer knows is false. In other words, if you adopt a false statement made by another person, that false statement will be attributed to you. Finally, the last sentence is very important, and we'll come back to it quite a bit. Partially true but misleading statements or omissions can be the equivalent of affirmative false statements. The idea here is that statements or omissions can be so misleading that they can be considered the same as outright lies. Of course, this opens up quite a bit of Rule 4.1 to interpretation and gray areas, but it's necessary to capture conduct where you can't point to a single lie, but where there are one or more misleading statements or omissions that really should be considered the same as affirmative false statements. Now let's go back to our hypothetical number 1.
Listen, Edward, I took your call, but I'm not prepared to negotiate. If you don't accept in full the terms as proposed in our letter, we're moving forward with a lawsuit. I have no doubt any jury would award us triple what we asked for.
I think we've already done a thorough job of thinking about whether the statement by Cade is or is not ethical. And I think it's almost more interesting to think about how you should respond to that type of a statement. In this case, you identify something that feels like a dirty trick and you say, great, now what do I do? Well, there's a number of things Edward could do, and we're going to look at a couple of those. Let's take a look at the first possible response.
Kate, you know that I never yield to threats, but I'm happy to focus on the merits.
Here, Edward is simply ignoring the threat and trying to just move past it. As I said before, there's certainly nothing wrong with this approach, and it could be a good way to go. But if your opponent is making these sorts of threats and you ignore it, the result may be that you force the other side to go through with it to try to save face. Certainly nothing ethically wrong with ignoring a threat, but it may not get you to the place you want to be. Let's take a look at another possibility.
That's fine, but if you file a lawsuit, I can tell you now, we'll never make a deal. And we'll defend your claims vigorously. It will cost you a fortune in legal fees, and you'll still lose in the end.
Here, Edward is responding in kind. He's making his own threat in response to Kate's threat. And as we've discussed, there's no prohibition on bad faith negotiation. So a threat in and of itself wouldn't be a violation of the ethics rules or any duty to negotiate in good faith. But more practically, interposing a threat against a threat is going to force a showdown. And you're either going to go through with your threat, make good on it, or you're going to let it pass and then you've lost credibility. Again, while there's no ethical problem with a threat just standing alone, it probably isn't going to get you to the place you want to go. Another, better alternative is something that we describe as painting a picture for the other side. One of my favorite techniques is to say something like, okay, I hear you saying that if we don't agree to this and exactly what you've said in your letter, you're going to file a lawsuit. Well, let me take you through what that's going to do on my side. When I report that back to my client, the head of the studio, he's going to say, okay, we're never going to negotiate with this person. You're never going to get any kind of credit for having developed this idea, and we're going to fight this until the very end, and they're going to go broke with their legal fees. If you give the other side a sense of, you've set in motion this chain of events, let me paint a picture for you of how that's going to play out. If that's not how you want this to end, we need to work together to suggest some other approach. I think it's often a very persuasive and powerful technique, and it also has the benefit that you can step outside of it to some extent, and you say, oh, this is how the head of the studio, my client, is going to be very likely to respond, and this is how it will play out. As I said before, separate the people from the problem and work together to solve the problem. I've seen this done very effectively in the mediation context where, especially at the beginning, you see opposing parties taking positions that you feel are extreme. And there's this temptation to respond to extreme proposals from the other side with an equally extreme or equally absurd position from your side. Of course, it's terribly unproductive, and hopefully you don't go down that path. One thing I've heard a mediator say that I thought was really effective is, okay, you would like to take the following position. Let me just repeat it back to you. And she repeated the very tough position. And then she said, how do you think that the other side is likely to respond to that position? And of course we said, well, badly. And she said, okay, well, how would you like for them to respond to the position that you're articulating? And we said, well, we'd like for them to maybe not love our position, but at least feel like there was something there that was reasonable, done in good faith, credible, and something that they could at least work from. And she said, well, why don't you come up with a position then that it's likely to elicit the response that you're telling me you would like? I thought she was brilliant because she got us to take a much more reasonable and I think fair-minded position, and the case was resolved. Let's take a look at another possible response from Edward.
That's interesting. Has your client authorized you to file a lawsuit?
This technique is treating Kate's threat as unauthorized, and it's clever to put Kate in a box and say, has your client actually authorized you to file a lawsuit? This is a very good technique because it then forces Kate either to tell the truth and say no, or to lie. If you force Kate to lie, as we saw before, you've now forced her into making an affirmative false statement of fact, and you've improved your position either way. Asking questions in a negotiation is always a good idea, and often when you get in trouble is when you don't have an opportunity to ask questions, and instead you start making assumptions. For example, if you're negotiating by email and you don't take the opportunity to pick up the phone, that's when you find yourself making assumptions or having an inability to question what you're being told. The key difference between negotiating in person or telephone and by email is that in the latter case, you can frame your statements very carefully, and unless and until the email is followed up by a call, neither party will have the opportunity to ask questions of the other. A mentor of mine at Davis Polk was famous for saying, "Never assume a goddamn thing," and he was right. Asking questions is always a good idea in a negotiation, and I think it's a very effective technique here. Let's take a look at another possible response.
Kate, if your client really wants to work with us as a producer, we can't have him making threats like this.
In this response, Edward is emphasizing the interest that they both share in having a durable agreement. The notion that we can't have your client making threats if he really wants to be a producer on the show. That's another effective technique where you take a threat, turn it around and say, okay, you're interested in a continuing business relationship, but that's not the sort of thing we can have people that we're in business with doing. So one way to deal with this is to emphasize the joint interest of both parties in having a durable agreement. What Edward cleverly does here is to say, okay, if your client really wants to be a producer, wants to be in business with us, we can't have him making these sorts of threats. It's one way to take a threat, diffuse it, and also to make it clear that this is something that's not in your client's interest if he really is interested in working with us. This approach is similar to the one we talked about earlier, helping the other side see how their position is likely to play out. So you say, okay, so this is a show that you want to work on. Hopefully, or presumably, you think that's going to be a productive working relationship. There's going to be value created, they're going to develop trust, they're going to make magic together. How is making this kind of threat likely to help that goal? Essentially, what you're doing is trying to help your counterparty understand their own goals and that their tactic isn't likely to achieve those goals. Let's quickly go through a few more things Edward could do in response. One thing is to show how this threat is worse for both sides, so a slight variation on something we've already discussed. But again, playing it out and saying, all right, if you file a lawsuit, we're going to defend it vigorously. We'll both end up spending tens of thousands of dollars, potentially hundreds of thousands of dollars in litigation costs. Everybody's worse off at the end of the day. This is another example of showing how the other side's tactics fail to meet their objectives. Another thing that's possible is to consider going public, and going public raises a host of issues. You could do an entire program on when and when not to use the press in negotiations, and if this were a confidential negotiation that you wouldn't want out there, that might not be an option for you. But I think it's worth noting that you do have that option in certain cases. We've seen unions do this often very effectively. I also remember many years ago when Conan O'Brien was in a dispute with the NBC network, he wrote a letter addressed to the people of Earth, where he said NBC is not negotiating with me in good faith to host The Tonight Show. And that actually was very effective for Conan O'Brien. But it's definitely an option that's on the table, but not one that you should consider lightly, because it does put the dispute out there, and that ultimately may not inure to your client's benefit. In addition, sometimes it can make the entire dispute more difficult to resolve. We can all think of examples where someone has gone public in a negotiation and characterized the other side's efforts or lack of efforts. Think about any of the major sports leagues at one time or another, and it's a very high-risk move. Finally, once you do go public, it's difficult to then get the press out of the issue, assuming it carries enough interest. In general, going public is a very high-stakes move, and I don't think that it's usually very helpful, but rather it's the court of last resort. If you're making absolutely no progress and you feel that there's very little downside to going public, you might consider doing that. The last thing to discuss is the most creative and likely the best, which is to suggest a tolling agreement. It's an obvious and very wise choice in this circumstance because with the tolling agreement, you're giving something to the other side. They've worked a concession out of you that you're now agreeing to toll, and you also avoid any issue of requiring a lawsuit to be filed right away. That's a good example of how you can get creative. Everybody gets a little something, and that gives you more time to negotiate without a gun to your head or the need to call the other side's bluff. While I'm giving the example of a tolling agreement, there are companies that are philosophically opposed to tolling agreements because they believe that they preserve claims that wouldn't be filed if the statute of limitations were kept in place. I give these as examples, and please don't think I'm suggesting that these tactics are almost going to work in all or even most cases. I'm simply trying to give examples of how to use creative thinking to respond to a bad faith tactic in a negotiation. It takes a little more work to be creative, but it pays dividends in my experience. Let's take a look at the next scene.
Kate, we've got ironclad evidence that my executive Rick created Dog's Best Friend independently of the puppy love pitch. Your client's testimony can't compete with our third-party witnesses and contemporaneous records.
The ethical issue here is that Edward has no evidence that Rick created Dog's Best Friend independently of puppy love, apart from Rick's own self-serving testimony. This example turns out to be pretty easy. This is the clear, dirty trick. It's making up facts out of whole cloth. We use all these euphemisms, but let's just call it what it is. It's flat out lying. It's clearly unethical, and it's clearly fraudulent. It's false because there is no third-party witness. There are no contemporaneous records, and there's not going to be any ability here to hide behind the concept of materiality. Independent creation is highly material in idea theft cases. In fact, it's going to be the entire defense, and so we can't pretend that it's not going to be a problem. Edward's objective in saying this is to give the impression that his client has a strong BATNA, which always is highly material in a negotiation. As I mentioned earlier, there might be other types of misrepresentations that don't create the same kind of problem because they aren't material, but this isn't one of them. By contrast, there are misstatements of immaterial facts or contextual facts. This is the example of the negotiator who comes in and is attempting to create time pressure by saying, "My flight's leaving in 4 hours, got 4 hours to do this." Really, the flight doesn't leave until the next morning. I don't think it's good practice. I think that you are occasionally going to be found out. I think it undermines your credibility, but you need to understand that some of the folks that you're negotiating with or against are going to be misstating facts that they claim are not material. The other one you commonly hear is the impact that some negotiating behavior the other side's engaging in is going to have on someone else. For example, the other side says, "It's not going to go over well, and you know how cranky or difficult so-and-so is, and that's going to create a real problem here." Maybe that person doesn't even know what's going on in this negotiation. This is very commonly done, and I don't think those kinds of comments are taken terribly seriously. But I raise them to distinguish between misstatements of immaterial fact versus misstatements of material fact. I included this example to show that this clearly crosses the line. So what do we do in this situation? How do you deal with that kind of situation when somebody is saying something that's highly material and that's going to influence what you do? Are you stuck, or do you have some options? It actually gives you a lot of options, and let's take a look at the first one.
Wow, it sounds like you've got all your ducks in a row. So who are your witnesses, and what records do you have?
What Kate is doing here is asking for specifics. That's a great way to force the other side into making a material false statement, or in this case, more material false statements. It's a very effective technique to ask, well, what records do you have and who are your witnesses? In terms of delivering that message, one also can take the people out of it and make it more impersonal by saying something like, "Oh, we always verify. It's our policy. We always verify." Because maybe the other person may say, "What, you don't believe me? You think I'm lying?" And then you could say, "No, no, no, I'm not saying that. I'm just saying we have this policy where we just have to verify. It's company policy." Referring to company policy, whether in fact you have a policy on that or you don't, is a negotiation technique in and of itself, but it's one way to get at the same result while depersonalizing it a bit so as to separate the people from the problem. Let's take a look at another response Kate could make.
You realize that your claim that Dog's Best Friend was created independently of anyone else's ideas, including my clients', is important to us, and we're relying on that in making this deal with you.
What Kate is doing is memorializing a statement and making it clear that it is, in her view, material and one that she's relying upon. She's effectively closing off these loopholes that otherwise might allow someone to escape liability for fraud or to escape from an ethical charge by saying, "I hear what you're saying and I regard that as material, and we're relying on that and agreeing to make a deal with you." It's a way of locking in the other side, and if the other side is not going to play the highest risk game, it may cause them to back down, and if they do that, then you've got a lot more information, in this case that they don't have any records or witnesses. It's a very effective response and a good technique to use. A related way to deal with this, in addition to getting the other side to confirm what is a material representation of something that you're signaling you're relying on, is to actually transfer the risk by putting these statements as representations in the settlement agreement, so that if the other side breaches it, you have a breach of a representation and you'd be able to access indemnification. I've seen it done very effectively where somebody will make a representation in the course of a negotiation. My favorite example of this was in a negotiation where the other party said something and I expressed great surprise and I said, "Wow, did I hear you correctly? Did you just say X? That's very surprising. I almost thought I misheard you." You can imagine that if that's the case, then that's going to be very important to my client and it may well move them off their current position. So you're not going to be surprised if we need to put that into the agreement as a representation. I just don't want you to think that we didn't hear you on that. I mean, if that's in fact the case, we're going to need to get that nailed down. In this case, the other side quickly backed off the statement, and in this sense, it's sort of a no-lose proposition. Either the other side backs down and you've established that they lack credibility on that point, and hopefully you have a better insight into their negotiating style, or if they stick with the representation, you now have it nailed down. And if it's false and they still put it in the agreement, you've built yourself an escape hatch. Let's look at a couple of other responses Kate might make.
Have you sold the format rights to Dog's Best Friend in any foreign markets?
The first technique is to ask a specific question in order to elicit more lies. Here, Kate is asking about having sold the format rights, and she knows that they already have done it. So she's setting Edward up to deny it falsely. We talked about the wisdom in general of asking questions, and here we see the technique of asking a specific question as to which you already know the answer as a way to elicit more affirmative false statements that will then set up a potential fraud claim or give you leverage later on. Let's look at another possible response.
What can you tell me about how Rick Stratton created Dog's Best Friend?
Now Kate's taking the opposite approach, still asking questions, but instead of asking a specific question as to which she knows the answer, she's asking a broad question. Tell me how you came up with this idea. It's fishing for more facts, and if Edward is going to continue down this road with more false statements, Kate is really building her record, and she'd be taking careful notes and anything else she could do to document this. If you feel in a negotiation that you're being lied to and that the other person is engaging in sharp practice, these techniques are great ways you can make a strong record that you can use either to potentially set up a fraud claim later or to build your case if you're actually going to make a complaint to the state bar. That's always an option, but it doesn't happen that often that lawyers report the conduct of others in a negotiation to the state bar. For the most part, the rules of ethics are self-policing. They require a complaint to be made, but you certainly would have that option. And if you've done your job well of asking a lot of questions and eliciting a lot of false statements and documenting that, you'd have what you need to make a complaint. I do feel strongly that if people are engaged in that kind of practice, people ought to report it. But it's not a necessary thing because your reputation is always going to precede you. Even if you have a clean state bar record, because no one has ever thought to report you, other people will know in advance of your reputation for sharp practice. People should be reporting it when it occurs because the legal ethics rules and the whole lawyer disciplinary system rely upon this self-policing. But a report to the state bar is not something you can use to respond to sharp practice in the moment. You need to rely on the techniques that I'm sharing with you here for that. This practice of asking very broad questions is similar in many ways to how skilled litigators take depositions. Sometimes you'll see them take it a step further and feign ignorance or act confused or that they need help. They'll say something to a witness like, "I don't do this every day. Can you please help me understand what do you mean by this and how does this work?" This approach of asking questions and getting the other side to educate you really gets them involved in providing a lot of potentially helpful information. It also makes it much more difficult for them to hide the ball or to deceive you because theoretically they're going to be telling a coherent story or at least trying to tell a coherent story. What we've learned as a result of this hypothetical is it's clearly unethical and a bad idea to lie. What Edward is doing here is just a straight lie, it's a straight misrepresentation, and we've discussed some techniques that Kate might employ to counter that. We know we can't lie in negotiations, but are there ever circumstances where we can be a little cagey? What does the guidance say about that? None of the rules says that there are situations in which you may lie. Of course, it's now going to turn on what do we mean by lie. There are ethical rules that talk about situations in which people are less than entirely forthcoming. We see a lot of these euphemisms, but what we're really talking about is exaggerating or understating things or overstating things. I think we need to go back. So the answer is it depends on the context. It depends on the type of statement, and it depends on the impact that the statement is likely to have on the other side. Of course, parties are making misstatements precisely because they hope that it will have an impact on the other side. So I wouldn't put a lot of stock in hiding behind the idea that it was immaterial, because then the question is, of course, why'd you bother mentioning it if you didn't think it was going to make a difference? Things got a bit murkier some years ago when an ABA committee on ethics took a very detailed look at exactly this kind of question. In 2006, that committee issued ABA Ethics Opinion 06-439, which provides a lot of detailed guidance for lawyers engaged in negotiations. I should note that ABA ethics opinions are not directly binding on lawyers, but they will influence state bar committees whose job it is to apply their state's ethics rules, which, as noted, in almost all cases are based on the ABA model rules. Most of the guidance in ABA Ethics Opinion 06-439 appears sensible and consistent with how we've been looking at Model Rule 4.1 and other ethics rules. ABA Ethics Opinion 06-439 provides a lot of detailed guidance for lawyers when we negotiate, so we need to review it in detail. The opinion starts by stating that, quote, "It's not unusual in a negotiation for a party to make a statement in the course of communicating its position that is less than entirely forthcoming." I don't believe that is exactly a revelation. The question is, what does it mean that most people are occasionally entirely forthcoming? Does that mean that they're lying? Does that mean that lying is okay? Is this somehow recognizing that lying is inevitable or authorizing lying? The opinion goes on and states directly that lawyers do not violate the model rules by misrepresenting, exaggerating, or downplaying several independent categories. They include a settlement position or a willingness to make concessions, a client's negotiation goals or objectives, the strengths or weaknesses of factual or legal positions, the value of the subject matter of the negotiations, that's similar to the price or value that we saw in Model Rule 4.1. And here's an important one, the lawyer's or the client's confidence in the availability of alternatives. This is the BATNA concept that we discussed earlier. So we have a list of categories of statements that don't violate the model rules according to the ABA Ethics Committee. This is the dreaded fake BATNA or the false alternative, and I do want to distinguish here between two very different types of statements. One type of statement is simply fabricating or making up a viable alternative that does not in fact exist. So in a car buying situation, it would be saying to the dealer, "I have an offer to buy the comparable car for $3,000 less than what you're proposing," when that is not in fact true. That's very clearly crossing the line. That's not what this is talking about. On the other hand, this opinion would seem to allow statements such as, I've spent all day here on the auto lot, I've looked at the prices, I've had discussions with these people, and I'm quite confident that I'm going to be able to buy a very comparable car for $3,000 less. That type of statement, and experienced lawyers will very clearly hear the difference between the two, is the kind that is permitted by the ethics opinion. But one part of opinion 06-439 that speaks directly to the issue of a client's bottom line is surprising. The opinion says, quote, a party's actual bottom line or the settlement authority given to a lawyer is a material fact that a lawyer may not misrepresent in a negotiation, end quote. I think a lot of people were surprised by this because most lawyers don't actually believe one another when they hear another lawyer say, my client's bottom line is $1 million. Does anyone ever believe that? I would think that would be one of the last statements by another lawyer that another person would be likely to believe, and therefore least likely to rely upon. And yet, making a statement about a client's bottom line turns out to be precisely what the ABA ethics opinion prohibits. So that is puzzling. The opinion says, and this is important, that a lawyer may, quote, downplay a client's willingness to compromise or present a client's bargaining position without disclosing the client's bottom line position in an effort to reach a more favorable resolution. So it creates this distinction between my client's bottom line is $2 million or $4 million, as opposed to we'd never accept that little money to settle our claims. This example might cause you to think about different strategies lawyers might use when people try to engage us on what our bottom line authority is, since lying about it is expressly prohibited. One of the things that we see lawyers doing now is not finding out what their client's bottom line is, because if you don't know what it is, you can't misrepresent it. The other thing we see lawyers doing is to refuse to engage in a conversation, claiming that it's privileged or simply deflecting the question. I find it's often easier when someone asks a question in a very pointed way, what is your client's bottom line, to ask the same question back. Usually they will respond with shock that you would ask such an inappropriate question, and of course it highlights how difficult the question actually is and how it puts the lawyer in an unfair position. Usually, the people asking that question aren't proposing that you trade that information. They would simply like for it to be coming their way. Applying the standards set out in ABA Ethics Opinion 06-439, making a false statement about your client's bottom line violates Model Rule 4.1. I would point out that even though a false statement about your client's bottom line is unethical, according to the ABA committee, I don't think it could ever give rise to a fraud claim, because I don't think anyone could show reasonable reliance upon that type of statement. And so the question is, of course, two questions. Number one, did the committee get it right? It's not allowing you to misrepresent your client's bottom line, but it is allowing you to misrepresent these other things that are important, like goals and objectives and alternatives. Some have written that the committee got it exactly wrong, and I would put myself in that camp. I think that I would never believe a lawyer who tells me what his client's bottom line is, but I might be tempted to believe a lawyer who tells me about his client's goals and objectives. And before seeing Opinion 06-439, perhaps I would have been more misled about that. And then, of course, the second question is, why is this type of conduct being allowed? And the opinion provides a comment on that. Quote, such remarks are often characterized as posturing or puffing and are statements upon which parties to a negotiation ordinarily would not be expected justifiably to rely and must be distinguished from false statements of material fact, end quote. Well, here they're creating this distinction between false statements of material fact, because it's relating back to Model Rule 4.1, which is dividing two categories, misstatements of material fact and things that are not misstatements of material fact. And then second, they're getting into this concept of reasonable reliance, which, as we suggested before, that's really the crux of it. What types of misrepresentations are likely to hurt the other side because they rely upon them, and which type are not? As I said before, I would argue that the committee got these categories backwards. I don't think that in general people have studied these exceptions and are framing their practice around them, but to the extent that we have the ABA Ethics Committee providing guidance on this, I would have hoped that they had changed this so that the types of things that people are likely to believe are not permissible misrepresentations. While we are focused today on the ABA model rules, which nearly all the states have adopted now in some form or another, including just a few years ago, California, I would be remiss if I didn't make a couple of comments about the legal and ethical standards that apply to California lawyers when we negotiate. While California follows the ABA model rules, California has on its books 3 statutes that predate its adoption of the ABA model rules that could be read to impose greater obligations on California lawyers than we find under the model rules. The first statute is California Business and Professions Code Section 6068, which requires, among other things, that an attorney, quote, employ for the purpose of maintaining the causes confided to him or her those means only are as consistent with truth, end quote. The second statute is Business and Professions Code Section 6106, which states that an attorney who commits any act of moral turpitude or dishonesty, whether or not in the course of the attorney's conduct as an attorney, is subject to disbarment or suspension. The third statute is Business and Professions Code Section 6128A, providing that, quote, every attorney is guilty of a misdemeanor who is guilty of any deceit or collusion or consents to any deceit or collusion with intent to deceive the court or any party, end quote. The additional caution for California attorneys is while you have the ABA Ethics Committee saying that you don't violate Model Rule 4.1 by making false statements about your estimates of price or value or your intentions as to an acceptable settlement of a claim, you have statutes in California saying attorneys may employ, quote, those means only as are consistent with truth, end quote, and expressly prohibiting them from engaging in dishonesty or deceit. While I believe the California State Bar and its courts would look to the guidance promulgated by the ABA when judging the conduct of lawyers when we negotiate, particularly now that California has adopted the ABA model rules, you should be aware that these other statutes exist where the language is admittedly vague, but also pretty absolute in requiring lawyers to employ, quote, those means only as are consistent with truth, end quote. You can add to that the non-binding civility guidelines issued for California attorneys we just reviewed as additional reasons to be cautious about taking sharp edges in negotiations if you're licensed in California. In 2007, the California State Bar issued a set of aspirational guidelines of civility and professionalism for lawyers. The guidelines include Rule 18C, which provides that, quote, an attorney should avoid negotiating tactics that are abusive, that are not made in good faith, that threaten inappropriate legal action, that are not true, that set arbitrary deadlines, that are intended solely to gain an unfair advantage or take unfair advantage of a superior bargaining position, or that do not accurately reflect the client's wishes or previous oral agreements, end quote. But these rules are only aspirational, and no lawyer, not even lawyers who practice in California, can be subjected to an ethics complaint for having violated any of these guidelines. Let's take a look at a scene that illustrates very clearly this problem of misrepresenting your client's true goals and objectives.
My client Alfonso is a true artist and dog lover. He doesn't care about the money. What he wants is credit for creating Dog's Best Friend and to work on the show as a producer.
The ethical issue here is that Alfonso had told Kate that he only cares about receiving a large cash settlement from Silver Spoon and that he hates Dog's Best Friend and how it turned out, and he doesn't want to be associated with it in any way. This is a great example of why lawyers shouldn't be able to misrepresent their current position and their ultimate goals. One little note here for entertainment lawyers out there. When we say credit, we're not talking about WGA credit, because this is an unscripted program, but getting credit as a producer is what is being suggested. Kate is using the notion of a producing credit as a way to hopefully increase the settlement value of the claim and ultimately get more money for her client through the misrepresentation because she believes the studio would be unwilling to give her client a producing credit under any circumstances. The idea is by demanding something that she believes the studio would never agree to, it's a way to drive up the settlement value. Now, her client wants exactly the opposite. We've talked about the notion of interest-based bargaining and how we should all get together and talk about our interests, not only our positions. But based on the ABA opinion we just explored, it's probably not a violation for Kate to have misrepresented her client's interests as a strategy for hopefully driving up the settlement value, which is what her client truly does care about. I think that's certainly an issue, and it would turn in part on whether Edward ordinarily would be expected to rely on these statements. But in this context, I think there's a fair room for argument. So it clearly goes against the concept of interest-based bargaining, but given the ABA guidance, it's probably not an ethical issue. How might Edward respond to this? Edward has a couple of different possible responses, so let's take a look at one.
We could bring Alfonso on as a producer, but we can't afford to pay him anything in the way of a cash settlement.
This is another example of responding in kind or fighting fire with fire. In this case, you have two levers. You've got credit and you've got cash. One side does want credit, doesn't want cash. The other side wants exactly the opposite. If you suspect that the other side is misrepresenting which one they want, saying, I want all credit, I don't want cash, or vice versa, you can take precisely the opposite approach. And in general, when people are suggesting that they only care about A and not B, if they know that you can't do A, then they're really just going to do that so they can drive up the price, if the price is the second issue there. As with Kate's use of this technique, there probably isn't an ethical issue with Edward responding in kind. Let's take a look at another example of a possible response by Edward.
Alfonso would rather have credit and a one-year producing job at a salary of $50,000 than a $50,000 cash settlement with no credit or producing job?
Here, we see Edward testing the other side's true priorities. I sometimes think about this when you go to the eye doctor. The eye doctor says, is it clearer with A or B, and B or C or D? And eventually you're honing in on the exact priorities and preferences. The thing to be careful of here is that when you engage in this kind of brainstorming with your counterparty, they may hear that you have the authority to do any of the things that you're suggesting. So either depending on who you're speaking with, you may wish to avoid this altogether, because any hypothetical resolution that you mentioned, they may just assume that you have authority for. One way not to imply authority is to precede it with something like, I haven't spoken to anyone here about this, but just so that I can understand what you're trying to get at here, is it really more about having A, or is it more about having B? And is it more about having B, or is it more about having C? Most people want to be understood and to have their positions articulated and heard by the other side. So in general, you're going to get a little bit of traction when you're telling the other side that I want to make sure that I understand what's important to you here. In fact, you're probably going to get a pretty full and complete response. Let's take a look at another example of a possible response.
Let's get Alfonso and Rick in a room so they can talk about the creative direction of the program.
This is an example of finding either a very creative or a potentially very unwise way to cut through this. You're looking for a creative way to test for deception here. You know that Alfonso does not in fact like the show, and you know that he's not going to want to work on the show. And you're gambling that if you can get those two in a room, that's going to become very clear, and that the credit issue will somehow fall away because the disdain that he feels for the show will come across. Those of you who are litigators are probably going to be very concerned right now. Putting these people in a room, one might make an admission. You could always set it up as a mediation or use some other process to try to create confidentiality and protection in that context. And depending on the jurisdiction, it may not be that difficult to have it be considered a mediation if you use a third-party neutral. It doesn't have to be a retired judge. Sometimes engaging in a mediation is a technique people will use to create a context where people can be candid with one another. While not without risk, putting Alfonso and Rick in a room likely would smoke out the fact that Alfonso wants nothing to do with the new show, if that's your goal. Let's take a look at one final example.
Okay, we'll give Alfonso credit and a producer title, but no salary and no cash settlement. Do we have a deal?
What we see in this last example is one of the risks of making a demand that you're not sincere about. One of the risks is that the other side will accept it, so be careful what you ask for, because the risk is somebody says yes. And so in this example, they've said yes. They said fine, he can have credit and there won't be a cash component. If that happens, we start to get into this risk of not fulfilling one's duty, the most basic duty of lawyers, competent, zealous representation. I think lawyers who think that they're skilled at deceiving their counterparties should really be thinking twice, because this is exactly what can happen if you take it too far. Be careful what you tell people because they might believe it. The classic example is, my client won't accept less than $1 million for this. If that is taken at face value, the other side might just walk and there might not be a deal to be made when a deal was possible, and when a deal should have been made because both parties would have been better off with a deal than no deal. So be careful of other parties taking what you're saying quite literally, or they may not do that and can actually put you in a worse position. And you'd have a huge problem with your client, because if you have to go back to your client and say, okay, well, they're not offering any money and they're just offering you a credit and a producing role, and the client would say, well, that's exactly what I told you I didn't want. How did that come about? If the client learns that this came about because his lawyer demanded that from the other side and the other side said okay, then you have a problem as the lawyer. And it's not a good conversation to be explaining to your client, well, the way that I thought I would accomplish for you what you wanted is to represent to the other side precisely the opposite of what you wanted. I don't think that there are many clients, even sophisticated ones, who are going to be comfortable with that as a tactic or a technique. And you have to be careful that the other side doesn't simply allow you to fall on that particular sword. It's a very high-risk strategy for all of those reasons. Let's take a look at another part of the hypothetical.
Unfortunately, Kate, I'm leaving on a month-long vacation in the Mediterranean. Cell reception on those yachts is so spotty. I'm the only lawyer here, so if you don't accept the proposal I sent today, I'm afraid this can't get done until I return.
Edward knows that Kate is eager to finalize the settlement after months of negotiation. He also knows that if he can delay a little bit longer, the statute of limitations is going to run on Alfonso's legal claims. The ethical issue here is whether Edward's conduct serves any legitimate purpose, or if it's only done for the purpose of delay. The intent, of course, is to force Kate to capitulate to his demands today. There is ABA Model Rule 4.4, which provides that, quote, in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use any methods of obtaining evidence that violate the legal rights of such person, end quote. The question is whether that is triggered by this conduct, and it's arguable. There's also the non-binding civility guidelines for California lawyers that we discussed before, which says that an attorney should avoid any negotiating tactics that are abusive, that are not made in good faith, that set arbitrary deadlines, or that are intended to give an unfair advantage, among other things. It's arguable that by playing this sort of delay tactic and a time trick, Edward is engaging in conduct that is intended to, and in the case of the statute of limitations, potentially gain an unfair advantage, to string Kate along so that the claim may expire. You also could imagine a potential fraud claim here. So let's say that in the meantime they were developing another treatment based on the underlying script, and if the delay in reaching a deal or resolving this claim with Kate allowed them to produce a spin-off, and they would get ahead of Alfonso on a spin-off. These are other possible scenarios where Kate may well have detrimentally relied on the fact that she was negotiating with Edward and that she was damaged by that, and that a fraud claim possibly could lie in that scenario. How might Kate respond to this?
That's not a problem. We can continue negotiating by email while you're out.
What Kate's doing here is she's simply refusing to accept Edward's stated deadline of getting it all done today. You can imagine her saying, I'm so glad that you have the same sense of urgency that we do. We've been trying to get this thing resolved for a while, but we'd be happy to negotiate by email while you're out. Simply not accepting the deadline and making it clear that you're not doing it is, of course, one response. There are other ways to respond. I mean, you can give your own deadline. You can say, actually, it doesn't look like I'm going to have access to my client today, but if we don't have this thing resolved by 3 days from now, then we're going to file a lawsuit. The way that it's been set up by Edward is the two choices are resolving it today or resuming discussions in a month. Of course, that choice is really a false dilemma. There are other choices that are possible here. Kate could respond by saying, actually, here are your choices, resolving it within the next 3 days or a lawsuit. Changing the way the problem has been framed and framing the options differently is another effective way to deal with it. Another way we've talked about is you can just ignore it and you can call the bluff. You let the deadline pass and you just have discussions as though there never was any threat. You send the email, you communicate as though nothing changed. Lastly, we talked about the idea of securing a durable agreement, so that at least the legal claims are preserved and the statute hasn't passed. I think she's going to want to do that to make sure she doesn't commit malpractice anyway. Let's take a look at another scenario that's similar, but with some small differences.
Kate, I've been so slammed. I did get your email with the last proposal last week. I'll get back to you when I can.
What's going on here is that Edward is using delay to signal a lack of interest. By putting Kate in a position of constantly following up, Edward makes it seem like Kate is the only one who's interested in making a deal. In negotiation parlance, this is often called the slow no, where you're dragging your feet and intending to signal a lack of interest in making a deal. It's probably in the same category as the deadline hypothetical that we talked about before. The question of whether it's ethical or it isn't would turn on whether it's interposed solely for delay or whether there is some attempt to gain an unfair advantage. We talked about trying to drag this out so that a statute of limitations might expire or so that the studio could get ahead in developing a sequel, and I think those are the factors that would be at issue. How might Kate respond to the slow no?
Edward, we've waited 3 weeks for a response. If we don't hear back tomorrow, we're moving ahead with this litigation.
In this scene, Kate is responding to Edward's slow no in a pretty aggressive way. In fact, she's taking a page from Edward's own playbook and coming back with a take it or leave it position, saying, Edward, we've waited 3 weeks for a response. If we don't hear back tomorrow, we're moving ahead with a lawsuit. Certainly that's one way to counter the slow no. It's obviously, as we discussed before, a bit of a high-risk strategy. Whenever you put to the other side a take it or leave it position, it puts you in the situation of either having to go forward with your threat, in this case, filing a lawsuit if Kate doesn't hear back tomorrow from Edward, or letting your own deadline lapse and therefore losing some credibility. In any case, this is certainly one way to respond. It may or may not be the right one in the circumstances because it is high risk, but it's certainly an option Kate can pursue. The other thing I think is important here, whether Kate simply chooses to ignore Edward's lack of response or she takes a more aggressive position and makes her own deadline, is to never negotiate against yourself. This is just generally good advice in a negotiation. If you've made a proposal to the other side and they're coming back to you very slowly and giving you the impression that they're purposefully dragging you along, generally you don't want to negotiate against yourself, which by that we mean improve your offer or counteroffer without hearing something from the other side. That's one of the things that your opponent in the negotiation is trying to get you to do, and that's the one thing that you want to avoid. Whether or not Kate takes an aggressive position here and imposes a deadline on Edward to respond, or whether she simply waits and doesn't take the bait from Edward to improve her offer without some counter from his side, that's sort of up to her. But the worst thing you can do in this scenario is to just negotiate against yourself while the other side's not giving any ground. That's precisely what the other side's hoping you'll do. Let's take a look at another scene.
Believe me, Kate, I want to settle this just as much as you. I'm doing everything I can. But my insurer is really tough to deal with. If you can come down a bit more, maybe I can talk some sense into him and get your client $25,000.
The ethical issue here is that Edward hasn't spoken with his insurer about a possible settlement of Alfonso's claim, and Silver Spoons' insurance policy has a $100,000 limit. Is this ethical? Is this a dirty trick? This is the classic good cop, bad cop situation. It describes a situation in which you take one party and you divide them into two parts, one of whom is bad or cranky or difficult, and another who is reasonable and motivated to get a deal done. It comes up again and again, and of course it's difficult enough to try to negotiate with one counterparty. When you suddenly find yourself with two counterparties, it makes it exponentially more difficult. I should note that it's the rare negotiation where you really only have just one person or personality or set of emotions and interests on the other side. It's much more common to have several, whether or not the other side is actually using the good cop, bad cop technique on you. The good cop and the bad cop can both be in the room, or you can have this scenario, the good cop in the room and the bad cop not in the room. These are all techniques that can be used to separate the two. The classic example is the car dealer, where the sales rep is the good cop and says, "Look, I'd love to give you the car for that amount, but my manager is never going to let me do that." Is Edward's conduct here ethical? The question is, does mentioning $25,000 when the policy limit is $100,000 create an ethical issue? I think pretty clearly not, because there's no duty to inform the other side of the policy limit, and Edward didn't say that the policy limit is $25,000 when in fact it is $100,000. He's just trying to get Kate to agree to take $25,000. Now, there may be rules in the context of litigation or elsewhere where you have an obligation to disclose insurance policy information. But in this context, Edward is not factually misrepresenting the amount of the limit, and he is not volunteering it, so that's not going to be an ethical problem. This next one gets a little bit more interesting because Edward's statement about the insurer being tough to deal with suggests that there have been some past dealings and maybe some conversations. So it's at least implied that Edward had had conversations with the insurer and that the insurer had not wanted to pay any more than $25,000. If that's not in fact true, you potentially have an ethical problem. The question is going to be whether or not the fact that Edward did not have the conversation is material. One might say, yes, it's quite material because that's the basis for his information is a conversation with the insurer, and the insurer is the decision maker. Another person might say, well, the insurer is going to make whatever decision he's going to make, whether there was a conversation or not. That's not material. We've made it very clear that if Edward had actually spoken with the insurer and had actually lied about the settlement authority, for example, saying, my insurer can't go above $25,000 or the policy limit is only $25,000, then under Opinion 06-439, that is a flat misrepresentation of his client's bottom line or the settlement authority, and that's clearly going to be across the line. Let's take a look at some ways that Kate might respond to this type of a statement.
Look, I might be willing to accept $25,000, but there's no way I'm going to be able to sell that to my law partner. He insists on 6 figures in cases like this, no exceptions.
The first thing Kate might do is the quid pro quo. If you're facing good cop, bad cop, you can play good cop, bad cop right back. I think the analysis of that is pretty similar to what we just went through when Edward was doing it. Whether that's a particularly effective technique or it isn't, the other side may see that as exactly what it is, which is a quid pro quo, but it's certainly something you could consider. Let's see what else Kate might do.
Now, Edward, I thought you were going to be the bad cop and your insurer was going to be the good cop. Now let's get back to the issues.
This is one I really like, using humor to call out the good cop, bad cop game. Every negotiation is different, and you may have a very volatile personality on the other side, and you have to play it a little bit softer. But I frequently use humor, or at least attempted humor, in negotiations with pretty good effect. I had a deal some years ago where I knew the other side was doing a much bigger deal, and I was sort of making fun of my counterparty by saying things like, oh, you're in the office at 10 o'clock at night, you've got something big going on. I often find that humor is a good way in a negotiation to approach a difficult subject, or in this case, to call out a tactic that's being used on you. There's no ethical issue here either, and this one falls into the category of just giving you some practical advice. Let's take a look at something else Kate might try.
Do you and your insurer need time to coordinate? I'm hearing 2 different things.
This is often known as merging the police force. You take the good cop and the bad cop and you try to put them together. She's essentially saying, I'm hearing two different things, something from you, something from your insurer. I think you need to get on the same page so I'm not negotiating with two folks. Again, no ethical issue with this, and it's another practical way of dealing with somebody who tries to separate his client into two different parts and only wants to let you negotiate with one of the two. Let's look at one final thing Kate might try.
It sounds like your insurer is the one with the real authority here. Why don't I deal directly with him?
This is cutting out the middleman by saying, look, it sounds like the insurer is the one who has all the authority here. Why don't I deal directly with him or her? Again, a very effective technique to get past the artifice and have a single negotiation with the person on the other side who is the one who can make the decision and avoid any of the game playing. It's time now for a summary of what we've covered today. We've seen in the course of today's presentation the general rules that require lawyers to be candid in their dealings with others. That's ABA Model Rule 8.4, as well as the general rules that require lawyers to be zealous advocates, such as Model Rule 1.3. And we've discussed a fair amount today about just how zealous can you be and still stay within the bounds of these ethics rules. In general, you are not required to press for every advantage. You certainly can be reasonable in negotiating. You can take an interest-based approach to negotiating, which many top negotiators, myself included, recommend. And you're not required to fight over every last dollar. But there are certain pretty clear bounds that you still have to stay within. And that's really bounded by these rules, and then to a lesser extent, the ethics opinions that help to interpret the rules, but they themselves are not binding. I also cautioned you, particularly those of you who practice in California, about some statutes that exist and are binding, and that contain some pretty sweeping language that bars attorneys from being dishonest, that could trip you up even when other authorities, like ABA Ethics Opinion 06-439, suggest that certain conduct in the context of a negotiation would be okay. When we started today, negotiation ethics sounded like a pretty nebulous term, but we have ended up with some pretty specific takeaways. Clearly, you may not misrepresent your bottom line or the settlement authority that you've been given. We talked about how to deal with issues surrounding your bottom line or your authority. We talked about asking the other side what their authority is or what their bottom line is. We talked about ignoring the question. We talked about claiming privilege or otherwise dealing with it. But clearly, as a lawyer, you may not misrepresent your bottom line. It's better to speak of your client's inclination toward a potential agreement and not his or her bottom line. What else have we learned that is clear in this area? The rules do not expressly bar attorneys from misrepresenting facts or law if they are not material. We learned that that word material is going to be critical in terms of whether there's a violation. The rules also don't prevent attorneys from misrepresenting opinions or intentions or state of mind. Those are other categories of things that if you're negotiating with somebody and they're making statements about their state of mind or their intentions or their opinion, you want to be thinking about the fact that these may not be true. And in fact, if they're not true, it's not going to create an ethical problem for the other side. The rules do not preclude lawyers from misrepresenting their settlement positions. Different from bottom line, but their settlement positions clearly can be misrepresented. You want to be very careful when hearing statements like that. And that also includes statements about that side's willingness to make concessions. If you hear an attorney claim that their client is not willing to make any concessions, you can hear that and know that it's not going to be an ethical violation, and it very well may be misrepresented. Lastly, there is sort of a catch-all. Lawyers are not precluded by the rules from making misrepresentations that are not knowingly false, which is the language of ABA Model Rule 4.1. And you can be quite certain that if an opposing attorney makes a statement of fact to you that turns out to be false, that they will claim that it was not done knowingly. Remember, we saw the one example where Edward had misrepresented that he had third-party witnesses and contemporaneous records supporting his position, which turned out to be completely false. There's no doubt that's not permissible and would be a violation under the ethics rules. It also could lead to a potential fraud claim, assuming the other elements were present. Returning to the car dealer scenario, the difference between saying to the dealer that you're negotiating with, I have an offer from the dealer across the way to sell me exactly the same car, or a very similar car for $3,000 less than you're asking, can you beat that? If that statement is false, there is no offer from another dealer, that's clearly an ethical violation and the same as Edward's statement. The difference, though, would be saying something like, I've been on the lots today. I've done my research and I'm very confident that I can get a comparable car for $3,000 less than what you're asking. There's a subtle difference in language, but it's important where in the one case, you're making a false statement about a past event, an actual offer to sell you a car that's clearly material as it goes to the availability of alternatives. I think we've said a couple times is one of the most material things in a negotiation. So that's an affirmative false statement about a fact, a past event. That clearly would be an ethical violation versus talking to somebody about your confidence in being able to buy a car for less based on X, Y, or Z. It is subtle, but experienced lawyers will hear that difference, and when you're in a negotiation, you need to pay close attention so you also can hear the difference between those two statements. Obviously, one is a lot more wishy-washy, right? The one about confidence. So I think this distinction in practice actually works pretty well because experienced negotiators will immediately hear what you might call weasel words. When you do hear those weasel words, you know the other side isn't making a flat representation to you, and you can take that into account. The way the ethics rules work in this context actually fits pretty well with how experienced negotiators hear statements like that expressing confidence in one's alternatives, or a lack of confidence in your opponent's alternatives. There are other takeaways that I'd like you to have, not simply where the rules of ethics draw lines, but more practical advice about listening very carefully to the representations that are made to you, asking follow-up questions, always pushing and pushing to clarify statements that are made, asking questions to try to discover the other side's interests. All of those things are going to help you avoid being deceived when misrepresentations are being made to you in a negotiation. This brings us back to ABA Ethics Opinion 06-439, which is the most direct treatment of the question that we're talking about today: what ethical rules apply in negotiations? That opinion says that the lawyer you are opposing may, without violating the ethics rules, misrepresent her client's goals, the client's objectives, the strengths and weaknesses in the client's position. The value of the subject matter may also be misrepresented to you, and the lawyers you're facing may also misrepresent their confidence in the availability of alternatives. You want to listen very carefully to the language that they're choosing. When thinking about BATNAs, always remember you are not the only party that has a BATNA. If you spend all of your time trying to figure out what your alternatives are, you'll be doing exactly half of the analysis that you need to do. You also need to think about your opponent's best alternative to a negotiated agreement. I hope I've convinced at least a few of you that negotiation ethics for lawyers is not a complete oxymoron. There are rules. They are specific. It is possible to make informed judgment calls about these matters. And frankly, that the best practice is not to be looking for exceptions and looking for ways to exploit the exceptions. The best practice in general, to meet one's obligation of competent advocacy and your duties of candor, are to take the same steps that you would take as a matter of simple common sense. You will be much more effective and much more competent in your representation if you are following the rules in that way, especially over the long run. I also think it refutes the notion that lawyer negotiators are in any way limited because the way you should negotiate, just as a business person, avoiding sharp practice because reputational consequences, potential legal claims, for all of those really good reasons, and it ultimately can be counterproductive to engage in that kind of conduct, really dovetails with the ethics rules. Finally, to the extent that you're negotiating a deal on behalf of a client, presumably the goal is not to reach any deal. The goal is to reach a durable and enforceable deal, and your client is not going to be well served by engaging in conduct that, if it's discovered later, threatens the durability or the enforceability of the deal that you've reached. The client wants to be done with you and your legal fees the minute the deal is done, and they don't want to face the risk of a lawsuit for rescission or fraud or anything like that. The fact that you're being ethical as a lawyer really just falls in line with how you should behave generally, both to preserve your professional reputation and to best serve your client's interests. I hope you enjoyed today's program. Thanks for joining me.
Well, that's fine. But if you file a lawsuit, I can tell you now, we'll never make a deal. I'm sorry, let me stop. For sound, I keep touching my tie. Is that a problem?
If you refrain.
Yeah, okay. Thanks. Kate, you know that I never yield to threats, but I'm happy to focus on the merits.
That's perfect. Let's move to the next one.
Okay. That's fine, but if you file a lawsuit, I can tell you right now that we'll never make a deal, and we'll defend your claims vigorously. It will cost you a fortune in legal fees, and you'll still lose in the end. That's fine, but if you file a lawsuit, I can tell you right now that we'll never make a deal, and we'll defend your claims vigorously. It will cost you a fortune in legal fees, and you will still lose in the end. Well, that's fine. So Alfonso would rather have credit and a one-year producing job at a $50,000 a year salary than a $50,000 cash settlement with no credit or producer job. Producing job, I know. It kills me. That's fine, but if you file a lawsuit, I can tell you now, we'll never make a deal. And we'll decline. Kate, we've got ironclad evidence that my executive, Rick, created Dog's Best Friend independently of the puppy love pitch. I'm gonna go back.
Perfect. Great.
Right, cool. Did we get two of those?
Yeah, we did.
Okay, thanks. That's fine. But I can tell you now, if you file a lawsuit, lawsuits first. Let's see. Okay, we'll give Alfonso credit and a producer title, but no cash settlement. I'll just read it. Okay, we've got ironclad evidence that my executive, Rick, created Dog's Best Friend independently of the puppy love pitch. Your client's testimony can't compete with our third-party witness and contemporaneous records.
Third-party witnesses.
Witness says. Ah, there's a plural there. Missed that one. Okay, we've got ironclad. This is gonna be fun. Kate, we've got ironclad evidence that my. It's funny, I can't even read it. Okay, we're still going? Okay, cool. Okay, we'll give Alfonso credit and a producer title, but no cash settlement. No salary. Okay, if your client really wants to work with us as a producer, we can't have him making threats like this. Okay. If your client really wants to work with us as a producer, we can't have him making threats like this. Believe me, Kate, I want to settle this just as much, So Alfonso would rather have credit and a one-year producing job at a $50,000 a year salary than a $50,000 a year. Unfortunately, Kate, I'm leaving on a month-long vacation in the Mediterranean. Try that again. Stumble on Mediterranean. So Alfonso would rather have credit and a one-year producing job at a $50,000 a year salary than a $50,000 cash settlement with no credit or producing job. Let's get Alfonso and Rick in a room so they can talk about the creative direction of the program. Let's get Alfonso and Rick in a room so they can talk about the creative direction of the program. Let's get Alfonso and Rick in a room so they can talk about the creative direction of the program. Okay, we'll give Alfonso credit and a producer title, but no salary and no cash settlement. Do we have a deal? Okay, we'll give Alfonso credit and a producer title, but no salary and no cash settlement. Do we have a deal? Wow. Cool.
They all went that well.
It was so much fun. Thank you.
Thanks a lot, man. Yeah, I appreciate it.